When the Queen Mother died in 2002, she left behind an estate worth roughly £50 million: art, jewelry, racehorses, and property. Her will was immediately sealed by court order. It will remain sealed until 2092. That means no one alive today will ever read it. The question nobody asks is, what's in there that's worth hiding for 90 years? There's a procedural answer to that question. The legal mechanism is documented in statute and has been used more than 30 times by the British royal family since 1910. But there's also a financial answer, constructed not from the sealed document itself, but from the paper trail that surrounds it. Estate valuations reported in the national press, debt figures documented by biographers, jewelry records assembled by royal historians, art inventories partially visible through Forbes reporting and royal collection records. A court challenge that briefly forced the entire arrangement into public view before the door closed again. None of that evidence tells us what the will says. Together, though, it tells us with reasonable precision what the will is protecting. March 30th, 2002. Royal Lodge, Windsor. 3:15 in the afternoon. Queen Elizabeth, the Queen Mother, dies peacefully at the age of 101. 101 years and 238 days exactly, with her daughter, the Queen, present at her side. She had been suffering a chest cold since Christmas 2001. The official cause was old age. She had survived 2 world wars, the abdication crisis of 1936, the death of her husband, King George VI, at 56, and then 50 years of widowhood. A widowhood that was anything but quiet. She maintained Clarence House in London, Birkhall on the Balmoral estate in Scotland, and Royal Lodge in Windsor. She entertained extensively across all 3. She built a personal art collection that eventually comprised approximately 1,200 works, making her, by the art newspaper's 1997 assessment, the most important royal collector since the early years of Victoria's reign. She owned racehorses on a serious scale, supporting national hunt racing across multiple decades. She kept an account at Coutts Bank that periodically alarmed the people responsible for managing it. The Encyclopedia of British Horse Racing records the cancellation of racing fixtures for her funeral in April 2002. The same had happened for her husband 50 years earlier. The country mourned, and somewhere in the same window of days, an application was filed with the Family Division of the High Court. Under Section 124 of the Senior Courts Act 1981, wills deposited with the court are open to public inspection by default. Any member of the public can walk into the probate registry and request a copy of approved will. The law assumes publicity. A sealed will requires a judge's active approval to override that presumption. It isn't automatically granted to anyone, even royalty. Someone has to make the application, and a judge has to agree. The arrangement to seal the Queen Mother's will wasn't improvised in the hours after her death. The Evening Standard reported that the process had been drawn up around the time of Princess Margaret's death. That was February 9th, 2002, 6 weeks before the Queen Mother died, by the then Attorney General, Lord Goldsmith, Buckingham Palace representatives, and one of the most senior judges. Princess Margaret had died first. The architecture for both sealings was already in place when March 30th arrived. The Guardian, reporting on this 5 years later in March 2007, identified Dame Elizabeth Butler Sloss as the judge who sealed Princess Margaret's will in 2002. Whether Butler Sloss also presided over the Queen Mother's sealing, or whether separate proceedings involved a different judge, isn't confirmed in available records. No judgment from those proceedings was published. No named judge for the Queen Mother's specific sealing appears anywhere in the public record. The process happened, and the documentation of how it happened remains as sealed as the will itself. That absence is itself informative. When Prince Philip's will was sealed in 2021, Judge Sir Andrew McFarlane, then president of the Family Division, published a full judgment explaining his reasoning. He named himself. He cited the need to protect the dignity of the late Duke and his widow, Queen Elizabeth II. He chose a 90-year sealing period over the 125 years the Attorney General's office had proposed, finding 90 proportionate and sufficient. That transparency, that named judge, that published rationale, none of it exists for the Queen Mother's 2002 proceeding. The sealed document now sits inside what a court judgment describes as a safe, in which there are over 30 envelopes, each of which purports to contain the sealed will of a deceased member of the royal family. The president of the Family Division maintains that safe in London. It holds wills going back decades. 9 of the oldest, dating far enough back to have lost immediate personal sensitivity, have been surrendered to the Royal Archives at Windsor for safekeeping and academic research, with copies retained by the court. The Queen Mother's will hasn't reached that point. It won't for approximately another 70 years. When a Jersey accountant named Robert Andrew Brown challenged the sealings of both the Queen Mother's and Princess Margaret's wills, the case went to the High Court and then to the Court of Appeal. The formal citation is Brown versus Executors of the Estate of H.M. Queen Elizabeth the Queen Mother and Executors of H.R.H. Princess Margaret and H.M. Attorney General, 2008, EWCACIV 56. The Court of Appeal found that Brown didn't have sufficient private interest or standing to seek inspection under Section 124. He lost. The Guardian had successfully applied to open the private court hearing. Briefly, the process was visible, and then the ruling came down and the door closed. Jeffrey Robertson, QC, argued throughout that the decisions to seal royal wills were made without jurisdiction, according to a practice direction that does not exist as far as the law is concerned. He called the procedure plainly unlawful. Courts disagreed with him. But his objection stands in the public record, made by one of Britain's most prominent constitutional lawyers, resting on a genuine point. There is no specific statutory provision creating a royal exception to probate's public access rule. The sealing operates as a judicial convention, granted every time it's requested, never once denied. Every time it's been requested, never denied. That pattern goes back more than 100 years, and its starting point reveals what the tradition was actually built to protect. Prince Francis of Teck died in 1910. He was the brother of Queen Mary, wife of King George V, a senior member of the royal family whose will created an immediate problem. The Cambridge Law Journal's historical account documents the reason. Prince Francis had bequeathed the Cambridge emeralds to a woman identified as the Countess of Kilmorey, a married woman and former mistress of Edward VII. The emeralds had been in the family since 1818. Queen Mary, unwilling to have that bequest permanently recorded in a publicly accessible probate document, successfully petitioned a judge to seal the will. That is where this entire tradition begins. Not national security, not constitutional necessity, not statecraft. A set of emeralds going to the wrong woman. The Cambridge Law Journal also identifies sealed wills for Princess Beatrice, the youngest child of Queen Victoria, among others. The list runs through the 20th century and into the present. When the judiciary published an annex to a 2021 judgment, it revealed that the president's safe held the sealed wills of more than 30 individuals, a number that has continued to grow. Princess Margaret, the Queen Mother, Prince Philip, Queen Elizabeth II, all sealed, all for 90 years. Each sealing sits within the same class of concern: financial embarrassment, sensitive bequests, private relationships that the family preferred not to formalize in publicly accessible documents. The 1910 case established the template. Everyone since has used it. The Queen Mother's estate, as it turns out, provided material for all three simultaneously. The Guardian's report from May 18, 2002, put the estate range at between £50 million and £70 million. Wikipedia, drawing on research into the finances of the British royal family, records the figure as £70 million, equivalent to roughly £130 million in present values. An early Guardian estimate published the morning after her death put it at only £26 million, probably reflecting certain visible assets before a full accounting was complete. The uncertainty range spans £44 million. The sealed will is the document that would close it. Reconstructing the estate's composition from public sources produces a partial picture, notable as much for what it excludes as what it includes. Properties. The Queen Mother occupied Clarence House in London, Burke Hall on the Balmoral estate, and Royal Lodge in Windsor. None were her personal property. Clarence House is a crown building. It passed to Prince Charles after her death, as Wikipedia records, and is now used by King Charles. Burke Hall sits on the Balmoral estate as crown property, occupied by the Queen Mother under a lease or use arrangement. Royal Lodge was a grace and favor residence. She lived in grand houses that she didn't own. The one property she did personally own was the Castle of May in Caithness, a Z-plan tower house built between 1566 and 1572 on Scotland's north coast. Purchased in 1952 when it was, as Wikipedia records, in a semi-derelict state and painstakingly restored over the following years. She visited it every August and October from 1955 until October 2001, her final visit. But in July 1996, 6 years before she died, she transferred the castle and its surrounding estate to the Queen Elizabeth Castle of May Trust, established by deed on June 11, 1996. The castle's current owner of record is the trust, not her estate. The Castle of May almost certainly didn't appear in the sealed will at all. Similarly, in 1994, The Guardian reported that the Queen Mother placed approximately £19 million, described as 2/3 of her money fortune, into a trust fund for her great-grandchildren, including William and Harry, structured to pay out at age 21 and again at age 40. The Guardian's headline described the arrangement plainly: "The gamble that foiled the taxman." That £19 million passed outside the will entirely, through a separate trust mechanism before her death. Between the 1996 Castle of May transfer and the 1994 trust, a substantial portion of her identifiable assets had already moved out of the will before she died. What remained inside the estate, the art collection, the jewelry, the racing interests, cash, personal effects, and the financial obligations that had accumulated over decades. The art is where the scale becomes remarkable. The Art newspaper's 1997 profile described the Queen Mother as the most important royal collector since the early years of Victoria's reign, and noted that most of her art treasures are little known to the public. ArtNet's reporting estimated her personal collection at approximately 1,200 works, personal property, distinct from the Royal Collection Trust, which is state property managed as a charity. When Forbes reported on the art at Clarence House in May 2002, it noted something specific. Some works were being assigned Royal Collection inventory numbers beginning at 100,000. That numbering pattern suggested certain pieces were being classified as loans from the Royal Collection to the Queen Mother during her lifetime. Not her personal property, but borrowed state assets being returned. With 1,200 pieces and a complex long-term relationship between what was hers and what was the Crown's, determining which was itself a substantial legal exercise. A public probate record would have made those determinations permanently visible, available to any journalist or researcher. One reported valuation places the entire art collection at approximately £35 million, with a Monet landscape among the most significant individual works. Whether that figure accounts for the royal collection loan questions, and whether the Monet estimate is accurate, can't be verified from publicly available sources. The sealed will would answer both. Her racing interests, substantial and unquantified in the public record at the time of death. When Queen Elizabeth II's own racing interests were liquidated after September 2022, The Guardian reported proceeds exceeding £2.25 million and described Charles III as still privately owning dozens of thoroughbreds. The Queen Mother's operation had been running for decades longer than her daughter's on the national hunt side. No public valuation exists. Then there's the debt side of the ledger, the part that doesn't appear in tributes. The Queen Mother's overdraft at Coutts reportedly grew, over time, to £7 million at its peak. It was then reduced to approximately £4 million by the spring of 1999, with, as multiple sources note, the Queen's assistance. One biographical source names Sir Ralph Anstruther specifically as the person tasked with trying to keep the Queen Mother's spending under control, a job that clearly required genuine effort over an extended period. The nature of the Queen's assistance in reducing the overdraft isn't specified in primary sources. A personal loan from Elizabeth II, a guarantee arrangement with the bank, a cash transfer, or some combination. What's documented is that the figure was reduced and that the Queen was involved in reducing it. The joke attributed to Elizabeth II across multiple sources runs, Coutts would have folded long ago, but for Mummy's overdraft. Even as reported humor, it indicates the scale was significant enough to become a reference point within the family. A Springer academic chapter examining the Queen Mother's financial legacy states that she left an £8 million debt, although her estate could cover its repayment. That £8 million figure conflicts with the £4 million overdraft cited elsewhere. The gap probably reflects different approaches to counting total obligations versus bank overdrafts specifically. The estate of £50 to £70 million covered either figure comfortably, but a public probate record would have documented the debt in formal legal terms: to whom it was owed, under what accounting, and how it was settled. If the Queen's assistance in reducing the Coutts overdraft constituted a formal obligation to the estate at the time of death, Elizabeth II would appear in the sealed will as simultaneously the primary beneficiary and a creditor. That situation isn't illegal. It's exactly the kind of thing that generates coverage and public questions about financial arrangements inside institutions that prefer to operate without scrutiny. The royal family's own website confirms that the will included bequests to members of the Queen Mother's staff, specifying that those bequests will be subject to inheritance tax in the normal way. The phrase, "in the normal way," does significant work. It acknowledges, by implication, that the rest of the estate was handled under arrangements that weren't the normal way. Staff bequests were taxed at the standard 40% rate on amounts above the threshold. The bulk of the estate, the jewelry, the art, the cash, passed under the 1993 deal with John Major, free of inheritance tax entirely. That deal was legal. It was private. It was never legislated. And the sealed will is the document in which its full financial scope is recorded in binding legal terms. Now to the collections, because this is where the sealed document protects information that is specific, named, and genuinely valuable. In 1942, when Dame Margaret Greville died, she left her entire jewelry collection to the Queen Mother. Greville was a McEwen's brewing heiress, one of the wealthiest women in Britain, a dedicated socialite, and one of the Queen Mother's closest friends in the pre-war years. The bequest, known as the Greville inheritance, comprised more than 60 pieces of jewelry made by Boucheron, Cartier, and other major houses. The court jeweler describes the collection as arriving as though from a trunk. Inside lay a treasure trove of incredible jewels, more than 60 fabulous pieces. It was one of the largest private jewelry bequests in British royal history. 60 pieces is an almost incomprehensible inheritance. In the 60 years that followed, from Greville's death in 1942 to the Queen Mother's death in 2002, those pieces circulated through royal public appearances, some photographed extensively, others worn rarely with limited photographic documentation. The pieces that have been tracked over subsequent decades include the Greville tiara, also known as the honeycomb tiara, which the Queen Mother wore frequently enough that it became associated with her image. The Greville emerald tiara, set with diamonds and cabochon emeralds, the Greville festoon necklace, and the Greville ruby necklace, a 5-row pearl necklace, and the Greville teardrop earrings, both worn by the Queen Mother at her 100th birthday attendance at the ballet in 2000, documented by Town & Country. And the Greville emerald and diamond necklace, described in one account as having been worn by the Queen Mother only rarely, with limited public photographic record across 6 decades of her ownership. That last detail deserves attention. A piece of jewelry from the Greville bequest, held personally from 1942 to 2002, worn publicly only rarely. 60 years during which most people with access to royal photography would have had no way to locate it. The sealed will specifies where it went. The court jeweler has since documented that piece as worn by Queen Camilla, confirming that it passed from the Queen Mother to the Queen and eventually to Camilla. A second Greville emerald necklace, also described as having been rarely seen, made a public appearance on Camilla in recent years in what royal watchers described as newly brought out from the vaults. The Cartier halo tiara, from the Queen Mother's personal collection, was worn by Catherine, Princess of Wales, at her wedding in April 2011. Tatler documented this and traced the piece to the Queen Mother's collection. It passed from the Queen Mother to the Queen to Catherine. That chain of custody is documented because the piece was worn at a photographed public event. For pieces that weren't worn publicly after 2002, the chain of custody exists only inside the sealed will. The Evening Standard's coverage of the Robert Brown legal challenge named this directly. The sealed will would have revealed what she did with the Greville jewelry. Not just that she had the collection, but who received which pieces, under what terms, with what conditions attached. Did some pieces go directly to named grandchildren? Did any pieces carry restrictions, family loan arrangements, conditions of use, reversionary clauses? The will specifies all of this. Nothing publicly available does. Beyond the Greville pieces, the Queen Mother acquired additional jewelry throughout her life. The Baring ruby necklace, which the court jeweler documents as acquired in 1964, appeared at documented public occasions paired with Queen Mary's ruby earrings. Tatler's overview of the Queen Mother's tiara collection describes a body of work that extended well beyond the Greville inheritance and inspired future generations. Specific tiaras, their acquisition histories, and their subsequent distribution after 2002 remain unaccounted for in any public document. The art ownership question adds a further layer. Approximately 1,200 personal works, distinguished in principle from royal collection property, but the Forbes reporting from May 2002 suggested that distinction wasn't always clean in practice. Works being assigned royal collection inventory numbers at Clarence House after her death meant the boundary between personal property and state property required formal legal determination. Whatever the estate settled on, that determination is recorded in the sealed will's supporting documentation and isn't accessible. Fabergé objects appear in multiple public accounts of the Queen Mother's personal holdings. mentioned alongside jewelry and paintings in descriptions of what she left behind. Specific inventories of her personal Fabergé collection aren't in the public record. They would be in the will. 3 grounds on which the sealing can be explained, each grounded in documented evidence, each independently sufficient. The first is financial transparency. The 1993 private deal between the Queen and Prime Minister John Major arranged for the estate to pass free of inheritance tax. The deal was never legislated. Parliament never debated it. It operated as a private agreement between the head of state and her Prime Minister to exempt between £50 million and £70 million from a tax that applied at 40% to every other British subject with a large estate. A public probate record would have assembled in a single legally binding document the exact estate value, the exact debt outstanding, the precise mechanics of the tax exemption, and the amounts already moved through the 1994 trust. All of it available to any journalist for the cost of a probate registry fee. The April 2002 Guardian headline on the Great-Grandchildren's Trust used the phrase, "the gamble that foiled the taxman." That framing, a taxman being foiled, applied to a trust that moved £19 million of royal money out of the inheritance tax system while benefiting from parliamentary funding, would have been a considerable political story if presented in full formal detail in a public probate document. Sealing the will kept those numbers inside the family. The second ground is bequests. The 1910 Origin case makes this explicit. The entire tradition of sealing royal wills was created because a royal will once directed valuable property to the wrong person, and the family wanted that permanently excluded from the public record. The Queen Mother spent 50 years as a widow with a large, intimate household, staff, ladies-in-waiting, personal attendants, companions, individuals who had given significant portions of their working lives to her service. The royal family's own website confirms she made staff bequests. In an estate of this scale, significant staff bequests attract attention. Any bequest to any individual outside the immediate family would have been examined, contextualized, and speculated about in detail. The Evening Standard's phrasing was specific. The sealed will would have revealed what she did with the Greville jewelry. Not just that she held those 60-plus pieces across 6 decades of ownership, but who received what, under what conditions, formally. The sealed will has those answers. Nothing else does. The third ground is asset classification. The Forbes reporting from May 2002 documented works at Clarence House being assigned Royal Collection inventory numbers, suggesting some pieces were loans rather than personal property. With 1,200 works and a 60-year history of living in crown houses while assembling a personal collection, the distinction between what was hers and what was the state's required formal legal resolution. A public probate process would have made those determinations permanently accessible, potentially inviting legal challenge, or simply generating coverage of how the line between private and state property operated inside the royal household. None of these 3 explanations require the sealed document to contain anything scandalous in the tabloid sense. They require only what the documented record already confirms: a very large estate passing under a private tax arrangement, a 60-piece jewelry collection with individually named recipients, an art collection with ambiguous ownership boundaries, and a set of financial relationships that were manageable in private and considerably more complicated when formalized in public legal terms. Courts accepted the case for sealing. Geoffrey Robertson's constitutional challenge failed, and the arrangement that produced the sealing, coordinated between Lord Goldsmith's office, Buckingham Palace representatives, and a senior judge, assembled while Princess Margaret was still alive, wasn't accidental. It was planned. Hugo Vickers, who published his 2005 biography of the Queen Mother after clearly spending years close to the world around her, described her as a complex and consummate actress. The Herald Scotland used that phrasing in reviewing the book. An actress controls what the audience sees. She decides the frame. The performance is real enough, but the performance and the person aren't the same thing. William Shawcross wrote the official biography, published in 2009, authorized directly by the Queen. The royal family's own website confirms the arrangement. The Queen has entrusted the writing of the official biography of Queen Elizabeth, the Queen Mother, to Mr. William Shawcross. A biography authorized by the subject's daughter, commissioned by the institution, written by a biographer chosen for that purpose, is a document shaped by the access given to produce it. A separate, unauthorized account of the Queen Mother's life notes explicitly what the Shawcross biography chose not to recount. 2 books covering the same woman with meaningfully different accounts. Vickers himself wrote, in the context of his biography, that such horrid things come out about people after they die. He wrote that about the Queen Mother. In the context of a sealed will that exists specifically to prevent certain things from coming out after she died, the observation lands differently. The Queen Mother managed her public image across 50 years of widowhood with consistent discipline. She gave access selectively. She appeared, reliably and unfailingly, as the person she chose to appear as: warm, resilient, devoted to duty, devoted to her horses, devoted to the country that adored her. The Coutts overdraft, the Queen's intervention, the civil list income that never quite matched the lifestyle. These facts circulated quietly within the circles that needed to know about them. They didn't appear in the authorized biography. They appear in this script only because financial reporters, court documents, and a legal challenge briefly force them into the public record. A will, in ordinary probate, doesn't perform. It doesn't manage impressions. It records debts, assets, recipients, and conditions in the language of formal legal obligation, the one accounting that exists outside the control of the person who commissioned it. The Queen Mother's will, in ordinary probate, would have been that record. Instead, it's inside an envelope, inside a safe, inside an office in London, waiting. In 2092, someone will open a document and read the Queen Mother's final accounting. Every debt, every gift, every piece of jewelry and every painting, and every racehorse. And when they do, they'll know what everyone who worked for her already knew: that the most beloved woman in Britain kept secrets that took 90 years to expire. Subscribe for more stories like this.